everyone, welcome to the Hindu Current Affairs for Beginners. Before starting our today's session, first let us see answers for the questions from our yesterday's video. Consider the following statements. Mark-to-market price method is to evaluate the mutual funds above the maturity period of 30 days. Yesterday we have seen about these liquid funds. There we have seen that SEBI has asked those people to shift from amortization valuation method to this mark-to-market price method. So statement 1 is correct. And SEBI and RBI together regulates the mutual funds. Even this statement is correct. Both SEBI and RBI will regulate the mutual funds. As both the statements are correct, the answer here is C, both 1 and 2. The next question is, which among the following are the money market instruments? Commercial paper, treasury bill, certificate of deposits. All these three are the money market instruments. So the answer here is D, 1, 2 and 3. Now let's start our today's session. These are all the topics that we are going to cover in our today's video. Our first article is an effort to intimidate the media. This article comes under GS paper 2 under the topic of governance. The context of this article is that the Attorney General Shri Venugopal wanted to take protection under Official Secrets Act for revelations that were made by Hindu on the Rafale deal. Yesterday we have seen that Rafale papers were stolen. So from the prelims point of view, we should know what is this Official Secrets Act. This Official Secrets Act of 1923 is responsible for secrecy in government. This act was first enacted in 1923 and it was retained after independence. This law is applicable to government servants as well as citizens, and this act will provide a framework for dealing with spying, sedition and other potential threats to the sovereignty and the integrity of the nation. And this law makes spying and sharing secret information as a punishable offense. And this act clearly states that any action that involves helping an enemy state against India is illegal, and one cannot approach, inspect or even pass over a prohibited government site or area according to this Official Secrets Act. And the punishments under this act range from 3 to 14 years of imprisonment, and a person who is prosecuted under this act, he can be charged with the crime even if the action was unintentional and it is not intended to endanger the security of the state. This act will empower the persons who are in the positions of authority to handle official secrets, and others who handle it in the prohibited areas or outside them will be subjected to punishment as per this Official Secrets Act. The next article is Ayodhya Mediation ruling today. This article comes under GS paper 2 under the topic of governance. Here, before seeing about this article, first we should know about a concept known as alternate dispute resolution mechanism. It is an alternative to the conventional or traditional methods of resolving disputes. So this can be considered like out of court settlement that can be discussed by any party at any time during the litigation, and it is a cost-effective alternative comparing to a court trial. And this mechanism will facilitate resolution in resolving the matters of business issues and others when it is not possible to initiate any process of negotiation, or if they were unable to arrive at a mutually agreeable solution. Now, from where this alternate dispute resolution mechanism has got this power? It has a constitutional basis in the country, and this is established on the basis of Article 14, which deals with equality before law, and Article 21 that deals with right to life and personal liberty, and the directive principles of state policy of equal justice and free legal aid as engraved in Article 39A of the Indian Constitution. All this can be achieved through this alternate dispute resolution mechanism. what is the necessity for these mechanisms? It is because of two reasons. One is due to huge arrears of the cases and due to delay in justice delivery. Then how this mechanism has evolved? It is the Malamuth Committee, which is also known as Arrears Committee, that undertook a comprehensive review of the working of the court system, especially in the aspects of arrears and justice delayed. And they have stressed the need for alternative dispute resolution. And this resolution will consist of several techniques that will be utilized to resolve the disputes with the third party intervention without a traditional method for resolving the dispute. Now, what are the types of these alternate dispute resolution mechanisms? There are various types. They are arbitration, conciliation, mediation, and the other thing is judicial settlements inclusive of Lok Adalats. These four are the various mechanisms under this alternate dispute resolution mechanism. So now this article is all about the Supreme Court is going to rule that whether this mediation process has to be taken while dealing with this Ayodhya issue instead of a traditional method of resolving the dispute in the court. Now, what is this mediation method? In this mediation mechanism, the mediator, he or she will assist two or more disputants in reaching an agreement. Here, the mediator will be assisting them to reach an agreement. Here, the parties will determine the conditions of any settlement that has to be reached. Here, they will not accept something that is imposed by a third party. They themselves will determine the conditions for solving the dispute. And the dispute can involve states as parties, organizations, communities, individuals, or other representatives who are having any vested interest in the outcome. Here, these mediators, they will use appropriate techniques or skills to open and improve the dialogue between these disputants in order to help the parties reach an agreement on the disputed matter. The next article is the Imperial Cabinet and an Acquiescent Court. This article comes under GS Paper 3 under the topic of Judiciary. In this article, the author is critically examining two important judgments of Supreme Court. One is Aadhaar. If Aadhaar is a money bill or not as of this Article 110 of the Indian Constitution. Whereas the next thing is constitutional status to Delhi under Article 239 AA and democratic accountability. Here the author is critically examining these two Supreme Court judgments. So from the prelims point of view, we should know about these two articles. One, first of all, what is this money bill? A money bill is defined by Article 110 of the Indian Constitution as a draft law that contains only the provisions that deals with all or any matters that were listed in this article. And these provisions, they comprise a set of 7 features like imposition or regulation of a tax, regulation of borrowing of money by the government of India, and the withdrawal of money from the Consolidated Fund of India, and so on. It is the decision of the Speaker which is final to say whether a bill is a money bill or not, in case if any question arises. And moreover, the decision of Speaker is not subjected to judicial review. And the next thing is, let us see what is this Article 239 AA is about. Delhi being a union territory, it is not administered by the President acting through the Lieutenant Governor under Article 239, but it is administered under Article 239 AA. This was incorporated in the Constitution in 1992, and this article provides a special constitutional setup for Delhi. And this has provisions for popularly elected assembly, a council of ministers who are responsible to the assembly, and there is a certain demarcation of responsibilities between the Lieutenant Governor and the Council of Ministers. And according to this article, the Delhi Assembly can legislate on all the matters that were listed in the state list as well as concurrent list that are applicable to the union territories, whereas the public order, police and land are reserved for the Lieutenant Governor. The next article is probing the press. This article comes under GS paper 2 under the topic of governance, and this article is a continuation of the first article. In the first article we have seen about this Official Secrets Act, and now we are going to see about an act which is known as Right to Information Act of 2005. This article is saying that the Right to Information Act of 2005 is overriding the Official Secrets Act of 1923. If there is any conflict between these two in the era of openness, and it is better if the law is repealed altogether. This is what this entire article is dealing with. Now let us see about this Right to Information Act. It is a central legislation which will grant access to the government information to the public that is held by a public authority. And this act is established on the basis of two constitutional provisions. One is Article 19 that deals with freedom of speech and expression, whereas Article 21 that deals with right to life and personal liberty. The public authorities have to provide information that is sought by the citizens within the prescribed time limit as per this RTI Act. And this right to information will cover all the states of Indian Union except Jammu and Kashmir. This Jammu and Kashmir is covered under a separate act which is called as Jammu and Kashmir's Right to Information Act. And under this act, media is outside the purview of Right to Information Act. Then, under this act, can anybody avail the information? This is for the citizens of India only, but not for the foreigners or non-residential Indians. The objective of this act is to provide access to the information that is under the control of public authorities in order to promote transparency and accountability in the working of the public authority system, and to increase citizens' awareness by making them participate meaningfully in the development process. The next article is Breathing Clean. This article comes under GS paper 3 under the topic of environment, and the subtopic here is air pollution. This entire article is saying that the IQ Air Visual 2018 World Air Quality Report that has been published in collaboration with Greenpeace has underscored the levels of pollution in Indian cities. It has shown that out of 20 most polluted cities across the world, 15 are in India. From the prelims point of view, now we should know about a program that is mentioned in this article, that is the National Clean Air Program. It is a pollution control initiative that is launched by the Ministry of Environment in order to cut the concentration of particulate matter of 10 size and fine particles, that is particulate matter of size 2.5 by 20% and PM 2.5 by 30% in the next 5 years, with 2017 as the base year. And what are all the cities that will fall under this? Is this National Clean Air Program applicable to all over the country? No. According to the World Health Organization reports and air quality index data, only 1 or 2 non-attainment cities from 23 states and union territories were chosen as non-attainment cities. What are those non-attainment cities? We know that we have an index known as National Air Quality Index. These one or two non-attainment cities are the cities which have crossed these standards, which have gone beyond these standards. The Smart City project will be used for the cities that were falling under these non-attainment cities. Now, what is the objective of this program? It is to mitigate the actions for prevention, control and to abate air pollution and to augment the air quality monitoring network across the country and to strengthen the awareness and capacity building. So what is important from this article is we have said that this program has been launched by the Ministry of Environment. But in order to implement this entire program, which are all the ministries that were involved? We'll see those lists. Ministry of Road Transport and Highway, Ministry of Petroleum and Natural Gas, Ministry of New and Renewable Energy, Ministry of Heavy Industry, Ministry of Housing and Urban Affairs, Ministry of Agriculture, Ministry of Health, Central Pollution Control Board and also Niti Aayog. All these were involved in implementing this National Clean Air Program and in achieving their targets, that is to reduce PM10 by 20% and PM 2.5 by 30% in the next 5 years. The next article is Women and the Workplace. This article comes under GS Paper 1 under the topic of Indian Society and the subtopic here is Women. This article is a series of articles that were published in tune with International Women's Day. And this article is highlighting about the sexual harassment at workplace and what are all the obstacles for the women's participation at all levels of the workforce. And it is saying that all these were important and interconnected issues. And it is also talking about a Me Too movement which has prompted many of the institutions to examine their internal institutional arrangements like Internal Complaints Committee, which every organization having more than 10 employees should consist of an internal complaints committee, which will be used as a grievance cell for the woman who is working in that company to go and get her dispute resolved in case of any sexual harassment at that workplace. UN also has did the same thing and they had established a single window mechanism for hearing the complaints regarding this sexual harassment. Even India has passed a law that is related to sexual harassment at workplace. Sexual Harassment at Workplace Prevention, Prohibition and Redressal Act of 2013. And this act has laid down that every office in the country should have an internal complaints committee to investigate into the allegations of sexual harassment. But most of the companies, they do not have a trained manpower to do so. Here there is mention of a movement known as Me Too movement. What is this Me Too movement? It is a global campaign against the sexual harassment and assault where women from all over the world has opened up and shared their stories by throwing light on sexual abuse that is prevailing in our society. This hashtag Me Too movement has went viral in 2017 after sexual misconduct allegations against former American film producer Harvey Weinstein were made public. This movement has provided space for the people to express their experience of sexual abuse across the spectrum without having to be a specific issue. So all the countries and the institutions, they should function to innovate work environment towards this gender equity and violence-free work environment for women. The next article is Being Global. This article comes under GS Paper 2 under the topic of International Affairs and the subtopic here is International Institutions. So what is the international institution that is present here? It is the World Bank. This article is all about the US presidents Under Secretary, Mr. David is in the race for this World Bank governor. What is this World Bank? World Bank is an international organization that helps the emerging market countries to reduce poverty and share prosperity. This consists of two development institutions. One is International Bank for Reconstruction and Development. This will provide loans, credits and grants. The other institution is International Development Association, which will provide low or no interest loan to the low income countries. The other three organizations of this World Bank group are International Finance Corporation, which will provide investment, advice and asset management to the companies and the governments, and the other institution is Multilateral Guarantee Agency, which will ensure the lenders and the investors against political risk like war, and International Center for the Settlement of Investment Disputes. This body will settle the investment disputes between investors and the countries. This World Bank will provide low interest loans, interest-free credit and grants, and it will focus on improving education, health and infrastructure. The next article is Names for Lok Pal Shortlisted, Supreme Court told. This article comes under GS Paper 2 under the topic of governance. So from this article, now let us see what is the selection process for this Lok Pal. The names that were proposed by the search committee will be scrutinized by the selection committee, which is headed by the Prime Minister, and it comprises of Speaker of Lok Sabha, Leader of Opposition from Lok Sabha, Chief Justice of India or a sitting Supreme Court judge as nominated by the Chief Justice of India, and an eminent jurist as nominated by the President of India based on the recommendations of first 4 members of the selection committee through consensus, that is through mutual agreement. This is the selection committee for selecting the Lok Pal. What is this Lok Pal composed of? This institution itself is a statutory body without any constitutional backing, and it is a multi-member body made up of 1 chairperson and a maximum of 8 members. Who can be a chairperson? The chairperson is a person who will be appointed if he is a former Chief Justice of India or former Judge of Supreme Court, or if he is an eminent person with impeccable ability, special knowledge and expertise of minimum 25 years in the matters that are related to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. Then only the person can be appointed as a chairperson of this Lok Pal. Then what about the members? We have said that it will also have 8 members. Out of the maximum 8 members, half of them will be judicial members. Half of them will be judicial, and minimum 50% of the members will be from scheduled caste, scheduled tribe, OBC and minorities and women. The judicial member of Lok Pal should be either a former judge of Supreme Court or a former Chief Justice of High Court. Whereas the non-judicial member should be an eminent person with impeccable ability, with special knowledge and expertise of minimum 25 years in all these matters. The next article is India excluded again from student visa relaxation list. This article comes under GS Paper 2 under the topic of international affairs. So what this article is saying about is the UK Parliament has brought in changes to its immigration policy. In its immigration policy, it has listed some countries under low risk, but India didn't get placed in this list. It has excluded the Indian students from a new list of countries that were considered as low risk. So what will be the benefit if we are listed under this low risk countries? This will facilitate an easier visa application process to the UK universities. So now, as India has been left out of this new list, that means Indian students who are applying for similar courses will have to face rigorous checks and documentary requirements. The next article is large hydro projects gets renewable energy status. This article comes under GS paper 3 under the topic of economy. The subtopic here is infrastructure, and under this the topic is related to energy. So now this article is saying that the Union Cabinet has approved a new hydroelectric policy that is aimed to boost this hydroelectric sector by giving these large hydro projects the status of renewable energy projects. So what is the previous thing then? Till now, only smaller projects which are of less than 25 megawatts in capacity were categorized as renewable energy. But now, according to this new policy, even the large hydro projects will be designated as renewable energy projects, and the tag will allow these large hydro projects to qualify as part of the framework for non-solar renewable purchase obligation of the states. Under this, the power purchases, they have to source a portion of electricity from these large hydro projects. The next article is cheat devices. NGT tells Volkswagen India to deposit 500 crore. This article comes under GS paper 3 under the topic of environment, and the subtopic here is pollution. Here, Volkswagen India was asked to deposit a fine amount of 500 crore for damaging the environment by using a cheat device in its diesel cars by the National Green Tribunal. This company was found guilty of internationally programming its diesel engines with some cheat devices to meet the US regulatory standards, but they were actually emitting up to 40 times more nitrous oxides in the real world situations. So they have used some cheat devices to meet the regulatory standards. But the National Green Tribunal panel, they have used Delhi as base city to calculate the damages, and they have estimated that these Volkswagen cars have released approximately 48 tons of nitrous oxide emissions in 2016 alone, and they have determined the penalty based on these emissions because they found that these Volkswagen cars have used a deceit software that is installed in India. And from the prelims point of view, we should also know what is the difference between the National Green Tribunal and the Central Pollution for Control Board. First, what is this National Green Tribunal? This National Green Tribunal is a statutory body that was established under the National Green Tribunal Act of 2010. The objective of this National Green Tribunal is to provide effective and speedy disposal of the cases that were related to environment protection, conservation of forests, for seeking compensation for the damages that were caused to the people or property by violating the environmental laws that were specified while granting the permissions. The next thing is CPCB, Central Pollution for Control Board. This was constituted in 1974 under the Water Prevention and Control of Pollution Act of 1974, and it draws its powers from this act. And later, this body was also entrusted with in implementing the provisions of Air Prevention and Control of Pollution Act of 1981. What this body does is, it will promote cleanliness of streams and wells in different areas of the states by prevention, control and abatement of water pollution under this Water Act. And it will coordinate the activities of state pollution control boards and resolve the disputes among them. It will try to improve the quality of air and by using these prevention, control and abatement methods. And it is this authority which will lay down the standards that these water bodies and how the quality of the air has to be maintained. The next article is Cabinet empowers alternative mechanism on divestment. This article comes under GS paper 3 under the topic of economy. From this article, now let us see what is meant by this concept called divestment. It is nothing but it is opposite to the concept known as investment. Here, divestment means it is a selling an asset for either financial, social or political goals. Here, it is nothing but selling of our assets. The assets will be a subsidiary, business department, real estate equipment or other property. This will be done when the investments were reduced and firms they start withdrawing from a particular industry due to any political or social pressures. And this divestment will also make a company, but it will involve a company selling its assets to improve its value, and it will also make it obtain higher efficiency. Most of the companies they will use this divestment to sell off their subsidiary assets so that they will be able to manage or regain better focus on the core business. Now just try to answer this question. How is National Green Tribunal is different from Central Pollution for Control Board? And in our tomorrow's video, we'll see the answer for this question. Thank you.